All right. Let's get started. So the trial calendar today, we call it. It is a 1 week trial calendar that starts not next Monday, but the following Monday. And what will flow from today is a sense of which cases are going to go to trial. And then I will get an email out to all the lawyers who have cases that look like that might go to trial to let you know the order in which I will call those to trial. So we're going to sort that out. And then we also have a calendar, Mr. Korn, with your client where we need to talk a little bit about how probation has been going and not going.
Correct.
Okay, got it. Okay, position one on our calendar, trial calendar, is Germonta Rogers. That's Dennis Francis's client, and he's stuck in trial next door. So we need to work through the impact of his speedy trial demand. Well, the impact of his unavailability on the speedy trial demand. Mr. Rogers will be brought over. I don't think we'll do a whole lot of interacting with him. Co-defendant Mender will be brought over. His lawyer is in the same trial with Mr. Francis. He did not file a speedy, but the case is being propelled by the two speedies. And then the third co-defendant is Mr. Horn, and that's Mr. Rhodes. Hello, Mr. Rhodes. As your client, he will be here soon. Do you have an update on what we're doing with Mr. Horn's part of the case?
Yes, Judge, if I may, with open door indulgence, speak with Mr. Horn once he gets here. I did speak to him yesterday, communicated the offer, still needed some time to think on it.
Sure.
So I'll need to speak with him again today to understand the decision.
Got it. I'll certainly let you do that, and you can let us know. It's possible that what we have to do, unless you withdraw your speedy, is that we try Mr. Horn solo on the week of the 23rd. It may be that Mr. Francis's unavailability legally puts a pause on that speedy trial demand because we can't go forward without a defense attorney. But we can go forward with Mr. Horn because you're here. So we'll just need to weave that into the mix. If Mr. Horn says, I'm not interested in that offer, and for whatever reason, he wants to go to trial with Mr. Rogers, doesn't want to be severed out, then we'll need to figure out what you and he want to do with the speedy trial demand as well. But we'll talk about all that if he's working the case out today. That's moot. Okay. All right. Position 4 is Cordara Tuitt.
Morning, Your Honor. Fagan on behalf of Mr. Tuitt. We'll be ready.
Great. Good to see you, Ms. Fagan. You are newer to an old case. You feel like all the discovery is there? No concerns on that front?
I have everything. The only thing that I wanted to request from the court was I would propose order to bring my computer into the jail so that he can review.
Sure. If you will email that to Ms. Nelson, I will sign that so you two can definitely have that interaction.
Yes, sir.
Okay. He is here. He's up. Do you want to talk to him? Okay. Do we need to keep him around?
No, Your Honor. As soon as I get the short list, if he's to the top, I'll relay.
Okay, great. Then you don't need to stick around either. Up to you.
Thank you, Your Honor.
You bet. Mr. Holmes has already pled. Lionel Bateman.
Judge, I ask for attention.
Okay. Ms. Taylor has a couple cases here today. Have we heard anything from Ms. Taylor? We did hear from Ms. Gladden, who is encountering issues getting here, but we'll get here. Nothing from Ms. Taylor? Okay.
For yesterday, so I did. anticipated she would be here.
Me too, and she planted herself firmly in court earlier in the week and wasn't gonna budge, so we'll see. More importantly, her client's not here. So we'll do tentative bench warrant, but maybe they arrive together. We're only 15 minutes in here. Javaris Matthews. Oh, there are a few people online. Okay, no, Mr. Matthews. Okay. Ms. Hightower? Not yet, you're on a tear here. Bench warrants. Now, that's Ms. Taylor's other client. How about Mantrell Perry? Good morning, Mr. Perry. Got an update for me on Ms. Gladden?
She's supposed to be walking into the court, going to the other license.
Okay, we'll hold for her. You often know where Ms. Hightower is.
Supposed to be coming out the other way.
Okay, you think she's nearby? Okay, well, we'll see what happens. How about Daley Strickland? Ms. Wood, you were concerned about Mr. Strickland maybe not appearing. Okay. Bench warrant?
Yes,
All right. This is shrinking the trial calendar. Dante Edwards.
I just spoke to him right before he wants, so he's on his way. He is here.
Okay. All right. Tyler Thomas, I know is here. He's been making noise in the back. And you are the new lawyer on the case, not new as a lawyer, but new to Mr. Thomas's case. And we need to talk about information from the sheriff's office.
Correct. Your Honor, new as an attorney as well.
Okay, well, double new. Welcome. You work with Mr. Wolf?
Yes, sir.
Great.
So he's got two cases. We are ready on 24 SC 060. The prior counsel for the state had indicated they weren't sure if they were going to move forward with this. I don't want to put words in their mouth. That's where we're at on the first case. We're ready for that. On the other case, we had some discovery issues. I would like a witness list, which I haven't provided. And I open record requested the grievances from the jail during the virtual court period in our case. And so I was provided those for the open records request yesterday at 6 p.m.
Okay.
And the issue is I have some physical grievance records from the jail that is have been provided to me from his father, the carbon copies. And then the grievances that I was provided, those are not.
Okay.
So that's worrisome to me because the grievances essentially stop right before the ones I'm looking for.
Okay.
So I'm not really sure how to proceed on that. And I'd still like some information on the victim in this case, if he's being given called to testify regarding deals or incentives for testifying, things of that nature.
Okay. Well, let's find out from the state first, if we are to reach one of Mr. Thomas's cases, which one would the state go forward on?
Your Honor, we would be going forward with position 1524 SC 005283.
Okay.
The previous counsel offered to dismiss position 4 and with condition with a plea.
Okay.
To position 15.
Okay.
So that was only the condition that Mr. Thomas resolved that case.
Okay. But if we're going to go to trial, the state will go first with 15. And that's the one where you're having some discovery issues. Discovery, I mean that loosely, not that Ms. Davis isn't getting you things, but is that the case where the grievances don't line up, that kind of thing? Okay, well, we'll have a conversation about that this morning with your client out here. Cecilia Futch, I think she's online. Do we have an update as to Ms. Futch?
Yes, Judge, we did successfully have a proffer yesterday. And so we are just asking the court to place this case in a judicial hold until the resolution of the federal case in October. And then the DOJ attorney had assured me he will keep me updated if there was a plea that was.
Ms. Rios, any concern about what you just heard? So my plan is to put the case on judicial hold, put it on an inquiry calendar in early September. And we'll see if between now and then there are developments that would cause the state to say, we can just make this go away, you should certainly let me know. But the reminder for everyone will be an inquiry calendar in September. Okay? Ms. Futch, do you have any questions about what I just said?
No.
Okay. All right. If you end up with questions, reach out to Ms. Rios, okay?
Okay, thank you.
Thank you. Marcus Moment.
That is our friend that is still with Douglas County right now.
Okay. Right, you told me that, and I was gonna figure out what's going on with his bond. Okay. Remind me what he's in Douglas County for. Okay.
Yes, he has a new case, with us.
In Fulton?
Yes.
Okay.
I waived agreement on it recently, and then he's also got a situation in Coffee County. Cook County.
Oh, that's right, because I was there, there's a Cook County, because someone said that's in Illinois, and there is one, but not this one. This is one row up from the Florida border, Cook County. Adele, it's the county seat. Okay, so we don't have him here. Have you had a chance to talk with him about his goals and objectives with his Fulton cases?
So we're close to working them both out with a global resolution. It was a matter of getting all of his credit dates lined up because he's been back and forth so much. And then also, he just wanted to see the discovery on the fleeing case.
Okay.
So I did get that from the state, but he was taken back to Douglas before I could share it with him.
The fleeing case is the newest one or the one on the calendar? Okay, got it. All right. So do you know if there is some hold or something that will get Mr. Moment back here, or if in Cobb County they say, we're done, and he walks out, is he free to go?
He's got a hold on Cook.
Yeah, so if anything, they'll probably leave Douglas and get it to Cook.
Okay. But is there a Fulton hold? He has a bond, he clearly has a bond on this case. Because there's not a probation.
Yeah, he's now on probation with us.
Okay, got it. But his new case that he has a bond on that?
I'm not sure.
Do you have that case number? I won't look it up now. I'll look later. I'm just,
25 SC 002350.
okay. Okay,
And I don't have the bond information, but just from my notes, that was a 2022 case, and doesn't look like he's been out of any, he's been in continuous custody of various places since then.
oh, the 25 SC case is a 2022 incident?
Yes, Judge, from September the 3rd of 2022.
And it's a fleeing?
Yes.
Okay. All right, thank you. Position 18 is Jonathan Darcy. Mr. Darcy's here.
Darcy's here, Your Honor. We've spoken with the state. They have relayed an offer to us. I was speaking with Mr. Darcy. We are not going to accept that offer. There was an immediate motion that was filed on this case, but we're announcing kind of otherwise ready for trial.
We don't usually miss immunity motions. When you filed it, did you send a copy to Ms. Nelson? Okay,
Let me check on that one. I do believe that. I think we saw it yesterday. We sent it, but.
oh,
It was.
oh, yeah, look at that.
I think it was. Good.
Can I help you?
I'm sorry.
Okay. So you filed the immunity motion yesterday?
Should have been filed back in May, Your Honor, when we were at the final plea.
It was filed yesterday.
Well, that's an issue with the admin, it's not with the bound, but.
Okay.
Yeah. So we would like to be heard on that if it's possible, but if not, we're still not to make a trial.
Okay. All right. And Ms. Davis, you're ready on Darcy?
Judge, I'm going to get some additional time on Darcy, but my understanding this was going to be worked out, but the court, something report, I'll get myself ready.
Okay. If we were going to do an immunity hearing, would you be ready for that? If our trial calendar ends up not yielding a trial, and so we use that time for, or some of that time for an immunity hearing, would you be able to be ready for that? Okay. All right. So, anything you file, if it's a motion, you are required by my standing order to send a courtesy copy to Ms. Nelson. That way we know it's out there. So make sure your admin, that did not file the immunity motion until yesterday, does that going forward. And we'll add this to the may go to trial, but we need to work through the immunity motion.
Will we just get an email about we're on that court list for trial?
You will.
Okay. Thank you.
All right.
Yes.
Not quite yet. Ms. Davis.
Yes, the defense is permitted to file a late motion. I asked if the court would allow the state to file a motion. In this case, it would be, to the bond. There were some bond conditions that I believe will need to be heard on.
Sure. So a couple things. One, it is a late motion, but my understanding of the law is if I don't have that immunity hearing before the trial, that's problematic. You can file a motion about bond at any time. That deadline for filing motions is for substantive motions in the sense of I've got a motion to suppress where we need an evidentiary hearing. So an immunity motion, a motion to suppress, 404B from the state, something where we need to have a hearing before trial. That deadline is meant to, all right, let's tee that up so that when we get to final plea, ideally, I've ruled on is the confession coming in or the photo ID, et cetera. So mostly the deadline applies to what would be defense motions. The main one for the state is 404B. A bond motion, that could, or a motion to revoke or modify bond, that could be filed anytime because it might not come to your attention until 2 days before trial that X has happened or Y has happened. So don't feel like there is a prohibition on filing a motion to modify or revoke bond because we've passed that deadline. Things could change after that deadline that make that something that needs to be addressed.
And will we be able to, if I get that motion filed today or tomorrow, will we be able to be heard on the 23rd on that motion?
I'll need to see the motion and we'll figure out when we hear it. But that's one that I would prioritize. So it might be something that gets fit into next week. We'll see. How long do you think the immunity hearing would take?
I think like half a day, Your Honor, it's not, it's only gonna be 2.
Okay.
So.
All right. Ms. Davis, anything else in connection with Mr. Darcy's case?
No, Your Honor.
All right. Anything else from the defense side?
No, Your Honor.
Okay, you guys are free to go.
Okay, thank you, Your Honor.
Xavier Mosley is here. Ms. Wood, what's the latest in terms of how Mr. Mosley wants representation to work?
Well, when I saw him, he no longer wanted my services. However, Ms. Ross went to see him and he said that he was leaning towards working with me again.
Okay. Ms. Ross as in, yes, okay.
So I'm ready either way, so whenever the court has enough deputies, we can just bring them out, see what's next.
Got it. Okay. Javon Redmond resolved his case already. Mr. Dang, I saw him. He is here. Mr. Dang, good morning. Ms. Rios, what's the latest with Mr. Dang's case?
To the state a little bit more resolution.
Okay. So you're gonna pre-try.
Yes.
All right. So Mr. Dang, you'll take a seat. We'll see what's happening today. Mr. Gentle is here. Good morning, sir. There's his lawyer, Mr. Denslow. Good morning. We need to have the 702 hearing before we can go forward with trial. I don't think we'll get to that before the 23rd. I know there was a medical leave of sorts for your client that you reported back. It won't be as extensive as you thought. I can't remember if it overlapped with that trial week.
It's tomorrow.
Oh.
If all things go well, that's not gonna be an impediment.
Okay. Right, we'll see. And then did you have leave that overlapped with the trial week?
The last 2 days of trial.
Okay. All right. Oh, and thank you. Mr. Gentle was re-indicted to address the concerns raised in the demur. And so really what we need to do is arraign or waive arraignment on the new indictment number. And that kind of resets a clock anyway. So there's the medical concern, there's your leave, and there's, well, we have a new indictment. Not new charges, just cleaning up some inadvertent language.
And Judge, both parties received some homework from the court back on May 9th. And as of this morning, I'm receiving in real time some of the state's homework. So,
Oh, I know you were supposed to get, Ms. Clark is in trial right now, so I think Ms. Davis is standing in for her. But you were supposed to get Ms. Deal's CV. I know you got that. There was victim compensation something.
correct, I haven't received that yet.
Okay.
It exists.
I don't know that it exists either.
DFAX has let the state know that there are no records.
Good. We were supposed, that was the big to-do where, Ms. Clark, you gotta let us, that's a knowable thing. So DFAX records are out of the picture.
I would just like, if it's like an email or something, I'm sure it is. I just like that stamped into the record. So
Okay.
it's part of the record.
Okay.
We just received the 413-4 notice that was particularized.
Ah, right. That hit my inbox yesterday. So, okay.
The only other thing is I think we still need a particularized child hearsay notice.
That still hasn't been filed? Okay.
I have a list, Judge, but it sounds like we're moving this anyway. I will get with the state about what is still outstanding.
Sure. Right. Well, I mean, the child hearsay notice is on them. If they don't file it, they can't use it. So you're entitled to it. I don't think it's going to be profound in the sense of these are the outcry witnesses and they're talking about what the case is about. But I made it, I thought clear in my order, responding to your motions that if they file the notice, the hearsay, child's hearsay statute lets it come in, regardless of your constitutional concerns. It's been upheld, but they have to file that notice, and that's the trigger.
And I think and I'm sorry, I haven't actually received the orders yet, so I may be behind the ball. I need to read the orders. For me,
Okay.
that's probably on my end, Judge, but I hadn't received those yet, so
Okay.
that may be part of my problem.
Okay, they're out there. So you're gonna wanna read them.
Yes, I'll review those, and I guess what I was getting at, Judge, was back on May 9th, it was not that the notice hadn't been filed or not, but the particularity of it, what specific child hearsay.
Right, it didn't, the order was entered on the 9th.
I have a feeling I know where they are, Judge, they're in Ms. Fry's inbox and not mine. So-
Okay, I just get them e-filed, and so they go to, I mean, Ms. Fry is listed as the attorney of record, so maybe it went to her. Okay, and there's been more motions practice. Okay, what a case. What I think we'll do is have another round of emails with you and Ms. Clark to make sure if we have one more motions day, we're capturing the 702, the 404B, 413, and then it looks like there are a couple motions in limine that won't take long to talk about, but we could talk about in advance about witness accommodations. And by then, I'll just say that you have to have filed your child hearsay notice if you intend to use any child hearsay. Okay. Ms. Davis, anything you want to add?
No, Your Honor, I believe you covered it. I just wanted to make sure that he was aware that the state has filed motions in limine to accommodate a child witness, motion to eliminate any notice and petition for the court to consider 404B and 414 evidence. The state's hearsay notice for business records exemption, a motion to eliminate for confidential records. And the state intends to file a response in its amended motion as well.
And that,
Okay.
that third one, I think, was only if they're working facts records. That one's new, so I'm not worried about that.
Got it. And you've already objected to the motion to eliminate, so you're aware of some of this stuff.
I got that one yesterday and I filed my response yesterday.
Okay, I don't know how you got that, but you didn't get the order on the motions, but the filing system works in mysterious ways. Mr. Gentle, any questions about anything we discussed?
No, sir, I wanted to, tell you the medical procedure has been canceled.
Oh, okay. I hope you didn't cancel it because of this, because we were not going to be able to do the trial on the 23rd because of all these other motions that have,
No, they canceled.
the medical professionals did.
Yes.
Canceled as in you don't need it, or we'll see you in September?
They could not do it.
Okay. I don't want to get any more info. That's your, but I hope that's good news for you. I don't know, but thank you for sharing that.
Judge, that concludes my business making excuse.
Yes, sir.
Thank you. Thank you, Defendant.
Oh, no, you can't be excused. Are you waiving arraignment on the new indictment? Or do you want me now on the record to formally arraign, Mr. Gentle?
Judge, I'll go ahead and waive. I don't think we do. He's literate.
There's a form right there. It's the same two charges. All the state did was to correct the mistakes that you identified in your demur.
Fantastic. I will fill
So
it
if you'll fill that out, once you get that to Deputy Gordon, then you and Mr. Gentle can go. And Mr. Gentle, a waiver of arraignment is just the entry of a not guilty plea and a decision to have me not read out loud in court on the record what the charges are. And I understand why Mr. Denslow would make that decision. Okay. Michaela Kemp. Good morning.
Come on, Judge, I need to speak.
All right, pre-try. Tyrone Patterson was re-indicted. Mr. Patterson, are you here? He was, in case he was here. That's why, so Ms. Francis, I think, is on the call.
Yes, good morning, Your Honor. Attorney Brown Melcher here, and Ms. Francis is on the Zoom call as well.
Great, well, I appreciate you both being here. This case was re-indicted to add a few more defendants, so it's off. We will have to have a new arraignment date. It has a whole new case number. It's not a -01. And at that time, you'll get notice of that, Ms. Brown Melchor, but that'll be a time you all, meaning you and your client, telling you now, can appear virtually for that arraignment. You may choose to waive arraignment. And as long as you fill out the necessary paperwork, then you and Ms. Francis are excused from that arraignment.
Yes, Your Honor. I will make sure all appropriate motions and waivers are filed ahead of time.
Great. Thanks for being here.
Thank you. That concludes my business. May we be excused?
Yes,
Thank you. Good to see you.
same.
Thanks, Your Honor.
You're welcome. And then Amaya Harrigan? Okay. You think she's on the call? Okay.
I told her she would.
Okay. All right. She was excused. This is the third defendant for the re-indictment. And then we've got Mr. Dennis, Brenton Dennis. Mr. Bass is always here.
We're holding from this.
We're holding for his report. Okay. So let me try one more time with our folks on bond. Lionel Bateman.
Yes, sir.
Good morning.
Good morning, how are you?
Well, I like the jacket. Is Miss Taylor here?
She says I'll come pick you up to your house and let you know where she in court in Clay County, and she'll be here in a second.
She will be here?
Yes, sir.
Okay. All right.
She in Clay County right now. on Superior Court.
Okay.
Sent to a Humphrey level.
Okay, I'm not doubting that, and you're here, which is the most important part. It's just sometimes, tricky to track Miss Taylor down. So let's look up, see if she did.
And Judge, I did receive a text from Ms. Taylor about a couple minutes ago. She said that she is in Clayton County and she would text me when she's on the way.
Okay, got it. So Mr. Bateman, you're just gonna need to sit tight. Hopefully she makes it. How about Javaris Matthews? All right, so that will remain a bench warrant. Mr. Bateman is here. Ms. Hightower, did you make it? Good morning, Ms. Hightower. So you are in the same position as Mr. Bateman. You're waiting on Ms. Taylor and the same position as me. Okay, and then Mr. Perry, any update on Ms. Gladden?
She said she was put it in, now last time I talked.
Right, that's a long, slow pull in. Okay, we'll sit tight. You're here, so you and I won't go anywhere till she gets here. How about Daley Strickland? All right, that'll be a bench warrant. Anyone else come in, not here there? Yes, sir, you are?
Number 13.
Number 13. Oh, you were the one waving at your lawyer. Okay, she said you were gonna be here, so you're here, good. Ms. Rios, what's happening with Mr. Edwards? Okay, it sounds like then from the trial calendar, we're into the pre-trial phase where lawyers can talk with prosecutors. I would like one prosecutor to stay available so we can talk about Mr. Kowalski and the probation modification. I think that's sort of a Ms. Winfrey type case. It has Ms. Clark's name on it, but they're both in trial. So I don't know, I guess you're the only, I mean, you or Mr. Miller would need to be the stand-in on that one. All right, Mr. Abate will handle that. If you guys want to go into the jury room to pre-try with Ms. Davis, if you're a defense attorney who needs to bend her ear, head on into the jury room. We got a second deputy.
Yeah, it's only the 12.
Only till 12. All right, well, I'm only here till 1, so there you go. We'll at least knock out the Kowalski situation. Ms. Simpson, is there someone on the call from probation, or who's going to narrate what the concern is?
When he had he emailed me yesterday
Jury duty.
and told me he had jury duty, so I emailed you the cases it's pretty much the same what we discussed.
And then is there paperwork to, you got it. Okay. Okay. All right. So Mr. Korn, do you and Mr. Kowalski want to come on up here?
Sure.
Please? Just be at the podium.
Yeah.
One second. Who, Ms. Taylor?
Ms. Clark.
Oh. All right. Oh, Ms. Cabrera. Great to see you.
Hello. Hi.
Hey,
We're waiting on yours, but I came over here, can I be honest as to why I'm here?
you miss us. That's number one.
And I
You-
wanted to know if you have like tea or hot water, a cup and a lid.
As long as it's not for your client.
No, for me.
Okay, yes.
I have my own tea bags, I have my own sugar, but if you need a cup of hot.
Yes, we have a water dispenser that does cold and hot, so you can do that. Before though, there's a tax or tariff. Tariff will be hit. Mr. Mender, yeah.
Transferred to juvenile court.
Right. Is there anything as I understand it, we have to, the way it works is we do the plea here. And then there's a bunch of paperwork that says, yeah, you've pled, but really the disposition and the supervision and everything is in juvenile court. Okay. But that's a sure thing.
Yes.
Because there's still a speedy going for the two co-defendants.
Yes, I just haven't, Ms. Dillard has not given me the conditions of what that plea would be.
Okay.
Here, the last communication I had from her was only that it was being transferred.
Okay. Well, I don't know if Ms. Dilligard's gonna hold that one case, but it's Ms. Davis who is now,
What's her first name? Yes, I've got email communications from her.
Good.
Already, just not about this one.
yeah, some of your other cases. Okay, so, but it's a done deal that just need the fine tuning of what are the conditions of probation. All right. So when we can get you freed up and Mr. Mender here, we can do that.
Yeah, we just have a girl that is not gonna be here till 10 something.
Okay.
I was like, I'm gonna.
So we have a few minutes. All right, well, we'll do that. Your tariff is still running though. What about,
I feel like I'm multitasking. I come in and do the announcements
yeah,
in the middle of the trial that lasts till July 11th.
yeah, I heard that. That's sad. Are you and Mr. Francis co-counsel on?
Yeah.
Okay. That's a big blow to the criminal defense bar, having both of you tied up on one case. No, your only other position on the calendar where someone would have shown up, you have one bench warrant. Ms. Harrigan was excused. That case has been re-indicted to add more defendants.
That's what we're waiting on. And it hadn't, I think the last time I spoke to Ms. Harrigan, it hadn't been re-indicted yet.
It has now.
On notice.
Yep.
That it was going to happen.
Yep, it has now, so there'll be a new indictment date, arraignment date. I've already told the other defendants, the current defendants, that if they do a waiver, they don't even need to show up. So we can run it that way if the arraignment is during your many weeks next door.
If Ms. Nelson can just shoot me the case number, I'll have someone follow waiver.
Okay, great. That's it. So it was just Mr. Mender. I guess what we can try to do is work with your schedule. If his resolution of the case gets him out,
Do it during, so,
we could do it during lunch.
or there's a down week
Oh,
following Juneteenth.
okay.
So the week after Juneteenth, there's a down week on that trial.
Oh, the week of the 23rd.
Yeah.
So you could be here to try a case.
No.
Okay.
But the 27th, so the 20, I think it's the.
23rd is that Monday.
And then whatever that.
Our trial week is the week of the 23rd.
Okay,
Yeah,
I can do the plea there. We're not going to trial, Judge.
okay. So we just need to find a window the week of the 23rd to have Mr. Mender brought over and that works with your schedule.
Yes.
Okay, done. If you, is there anyone back there right now?
No, but I'll go back. I think that Mr. Francis might be on trial with Farmer too, so we need to check it.
Okay. But that's interesting. If Mr. Rogers, co-defendant amender, is also working out, we could do it during that down week, the plea. But that's a Mr. Francis situation. All right. If you go with Ms. Nelson, you've paid your tariff. Thank you.
I want to make sure it's right. I don't want to cause any more issues.
I didn't ready to call you. I was like, it might be in here.
Judge,
You good?
Before I leave, I just remember, you had me file a bond modification, which was the ankle monitor under the old indictment. Was that included in the court's previous orders?
No, I thought we had, so that hasn't been addressed? Okay.
I will email Ms. Nelson for.
Yeah. Yeah, thank you for that reminder.
I'll use your date. But hold on, it has to be surveyed, so we can't do it right.
I'm sorry, Mr. Kowalski, to keep you standing right there. This trial calendars are those kinds of things. And Ms. Cabrera, as you've heard, she's going to be hard to contact over the next few weeks. All right, Mr. Abate, we're going to talk about Mr. Kowalski now. He entered a plea a while ago, was given some sets of conditions consistent with the nature of the offenses, and probation has indicated that there have been a few hiccups on that. I guess, Mr. Korn, I'll start with you. I don't know if you had a chance to either speak with Ms. Simpson or the officer who has been supervising Mr. Kowalski.
I spoke with Ms. Simpson.
Okay, so you're familiar with what the concerns are? Ms. Simpson, what are the proposed tightenings of conditions that would address these?
Mr. Kowalski needs to make sure that he understands that he is not permitted to be on any form of adult sites or his conditions that he acknowledged in August when he did his plea, as well as to make sure that he can find the clean term. He can't put himself in positions to where he can find himself
Okay, so the officer who's been working with Mr. Kowalski has determined that these two issues, one of which to me seemed kind of serious, for now merit administrative sanctions.
Yes, he's not had any problems with him thus far since he began probation, and which is why he's allowing this one time to just be an admin.
Okay.
But he needs to understand that we come back again, there will be a warrant issue.
Okay. The first incident at the end of last year, no reason to believe that Richie was a minor?
That it was not conveyed to me, from my understanding, that incident was with an adult.
Okay, got it. Mr. Korn, anything you want to add?
Your Honor, any lecture that you would give, I've already given Mr. Kowalski, and probably you do it quieter.
Probably.
He is aware of the conditions that he is obliged to meet. He was not involved in any kind of child porn or anything like that. It was purely adult stuff, and no one knew about it. He admitted to it.
Okay.
That was my understanding.
So one, it sounds like there was an alert because of the software on his device. So he may have admitted when confronted with it. The other, there were admissions following a successful polygraph.
Right.
Polygraph went well, but hey, I need to let you know, I'm doing these things, all adult related, but not consistent with some of the conditions of probation.
Right, and one of the conditions on the supplemental conditions that sex offenders receive did include no adult sites at all.
Right. Okay. Mr. Kowalski, the ice upon which you tread is very thin now. And I say that only because the conditions are the conditions. You may feel like they're onerous and restrictive. And what's the harm if a grown adult and a grown adult talk about things or look at things? And that's a fair perspective. It just doesn't apply to your situation. You agreed to a plea and committed to a plea that places those restrictions on you. And so if you prove that you're not able to abide by them, then you heard what Ms. Simpson said. The officer with whom you're working is probably going to take out a warrant. And if it's based on this kind of stuff, I'll sign it. And then you go into custody, we'll have a hearing. And it's not that I necessarily revoke 1,000 years of your sentence, but you don't want to be sitting in jail, even if it's for 2 months while we're working through the process. That is one of the last places I assume you want to be. So I guess in a quieter way than Mr. Korn may have, I'm letting you know that this was your grace It sounds like you were upfront on one of them and didn't deny the other, but you're going to need to be more cautious in the things that you do going forward. Does that make sense? Mr. Abate, do you have anything you want to add from the state? I know you are sort of just at the periphery of what this is all about.
No, you're not to understand what the issue was. It sounds like Mr. Ford yourself and the citizen have more than adequately covered it.
Ms. Simpson, were there administrative steps taken beyond tightening up the conditions of supervision, or that was the extent of it?
That was the extent of it. The officer just was sent to re-sign the updated conditions and I'll get it to you to sign.
Okay, you've got them here, so I can see Mr. Kowalski sign it?
Yes.
Great, all right. Have you had a chance, Mr. Kowalski, to speak with Mr. Korn about what the updated conditions are? Okay, well, why don't you two look those over, because I need to make sure you understand them, and you may object to one, and then we have to chart a different course.
Can I add something?
Can you add something?
Can I say something?
Sure.
That thing with Richie wasn't unsolicited. I think a text that he had sent me was unsolicited that my phone obviously caught because of being monitored. And I dealt with my probation officer and her boss about it. And she said, I mean, obviously it was a violation, but it was unsolicited to me. I had requested it. He sent it to me. I've since let him know, like, hey, you can't do this.
Oh, so I'm sorry to interrupt, but I just want to make sure, because the way what I received was written was that there was an exchange, and the result of the exchange was an invitation from you to Richie. Is that not how it played? It may be that Richie started the conversation, but that it culminated with you saying, come into my truck. That's not what happened?
No, sir.
Okay, all right. Then something got lost in translation. But the person who is closest to it, your officer, clearly deemed that it only merited these administrative changes and not anything more.
Second offense, before my polygraph test, I had admitted to him early on in this whole process.
Okay.
That I had admitted with my husband. On 2 occasions, I admitted to.
Okay, and that's clear. It says you admitted. It didn't say there was any sign of deception.
Not something that we do.
Okay.
We're not doing it anymore, so I take this very seriously.
Good.
Other team.
And the not anymore is the important part.
Yes, sir.
And as Mr. Korn said, these are restrictions on what would otherwise be lawful activity. I'm not thinking, gosh, why are we being generous with this guy? Using drugs is illegal. Why are we giving him a second chance? It's not illegal activity. It's activity that you're prohibited from doing. And that's a constraint, but it's one that you agreed to in exchange for the sentence that the state ended up recommending. So why don't the two of you look at those conditions? I don't want you signing something if you haven't had a chance to read it. And if you need it explained by Mr. Korn, it's been explained to you before Bruce Kowalski puts his signature on there. Okay. And then once it's been signed, you're free to go. Just get it to Ms. Simpson. You don't need to stick around. Okay. All right. Ms. Wood, we have anything we can do from your side?
Yes, Judge, position 23, Ms. Kim. She would like to remain on top.
All right. All right, Ms. Kemp, so I will slide you across from the working the case out to trial. And I'll be sending an email to Ms. Wood and the other lawyers later this week, maybe early next week, about the order in which we're calling cases on Monday, the 23rd. And it may be that you need to come back here to this courtroom that morning, even if you're not first up, because cases have a way of resolving when a defendant and the state are told, hey, we're about to bring in 48 jurors, and it gets very real. So even though you may be number 3 or 4 on the list, you might suddenly be number 1. So just make sure you're keeping the week of the 23rd open, because we could well reach your case and take that to trial, and it'll be a few-day process, okay? Any questions about that? All right, and you've got good contact information for Ms. Wood? All right, then stay in touch with her, and I may see you on the 23rd. If your case is far enough down the list, I won't make you show up, because I'll be pretty sure we're gonna reach something ahead of it, and then you just move to the next trial calendar. All right?
And Judge, whenever we can, I'm ready to bring Mr. Mosley out.
Okay, why don't we do that? That's perfect timing. We've got Mr. Abate here.
Yes, yes, thank you. Good, how are you? Good.
Good morning, Mr. Mosley. Good to see you again. How you been? You're going through it? Okay. I don't know exactly what that means, but you're here and you're walking, so those are good things. We are talking about the trial calendar for cases that would go to trial not next Monday, but the Monday after, June 23rd. And your case is close to the top of that list. It's very likely that we would do your trial the week of the 23rd. You and I had a good conversation a few weeks ago about representation. You had told me, Judge, I think I want to represent myself. I feel like I know this case better. No disrespect to Ms. Wood, but I want to do this thing. We talked about it more. And by the end of that conversation, the sense I got was that you preferred to have Ms. Wood be the lawyer, which doesn't mean you're uninvolved, but it means this is the person who makes the argument to the jury, who helps pick the jury, all that kind of stuff. That's how I thought we left it. But fast forward a little bit, Ms. Wood came back to me recently to say, well, now Mr. Mosley was saying, nope, he wants to go back to representing himself. But fast forward even more, you had a conversation, I've been told, with Ms. Ross, who is a colleague of Ms. Wood. And you had told Ms. Ross, I think I'm all right having Ms. Wood, meaning having a lawyer do it rather than Mr. Mosley do it. I need you to tell me, because as we're gearing up for trial, not next Monday, but the Monday after, I just need to make sure, is it going to be Mr. Mosley representing himself versus the state, or is it going to be Mr. Mosley represented by Ms. Wood?
By Ms. Woods.
Okay. Ms. Wood will likely have a trial partner sitting with her as well for the trial. So you actually have two lawyers with you, and you may well have met the other one before. They rotate who the junior partner, if you will, is. And that doesn't necessarily mean junior in experience, but the person who will do less of the work on the case. But you'll likely have two lawyers, Ms. Wood in the lead, plus one. And we would get you back here on the 23rd. Between now and then, Ms. Wood will be working with you and your family to figure out how to get some clothes ready for you. Fantastic. Those clothes are already here, so you will be dressed out, and I don't look like I'm wearing street clothes, but street clothes for the trial. And we'll let Ms. Wood do her thing on your behalf. You good with that? Okay. Any questions about anything?
Well, I had questions about my housing at the facility at the Fulton County Jail.
Sure.
Because I keep getting attacked and assaulted, and I'm informing the officers and my lawyer, but I ain't getting no help, so I'm being forced to defend myself again. And
Okay.
these situations might occur in a similar situation.
Right, and we don't want that to happen. Tell me what floor you're on.
6th floor.
Okay, south or north?
South.
Okay,
But they just moved me to a reasonable dorm where I'm at now.
oh, so you're in a better place.
Yeah, cause I just, on the 16th of April, I just got stabbed up in my sleep.
Okay,
That's why I had to cut my hair.
okay,
I wouldn't have did it if I had that incident.
okay. But right now, the dorm you're in or the block you're in is more, I think you used the word reasonable. It's a better place or not?
Yeah. Yeah,
It's okay right now.
yeah, it's been okay, but.
Okay, well, do me a favor. If where you are now becomes unsafe for you, let Ms. Wood know, or Ms. Ross, anyone that you talk to from her team, they'll let me know, and then I can talk with the chief jailer about getting you into a different spot, because between now and your trial, I want you focused on getting ready for trial and not, is someone gonna stick me in the back? But it sounds like where you are right now is better. As long as it stays better, then we don't need to worry about it. But if it gets bad, let Ms. Wood know. Will you do that? Okay. Any other questions? Okay. I will definitely see you on the 23rd. There's one case ahead of yours with what's called a speedy trial demand with a juvenile. That may be resolving today, but if it doesn't, I have to tackle that one first. But Ms. Wood's going to keep you posted on that. All right? Ms. Wood, anything else on behalf of Mr. Mosley? And Mr. Body, the state is ready to go on the 23rd in this case? Okay, then I will see everyone then. I'll see you soon. Remember, let us know if something happens, okay? He signed it?
Yes.
Great, yeah. Yeah, I'm curious to see what the tightening up is. Thank you. Mr. Slayton, I don't mean to leave you hanging there. I know you don't need to pre-try with Ms. Davis, but I do need Ms. Davis out here while we work through the issues you're running into.
Is she here? I would like to speak, retry it.
Yeah, she's back in the jury room with other defense attorneys, so feel free to head on back there. They're up. Okay. Will you let Mr. Rhodes know that his client's up? Would he be able to talk to him?
Yes.
Okay. Because that's the one with, yeah, just follow Deputy Gordon straight on back. You helping us out? This is a deep cover look. It sort of threw me. Undercover deputy. Thank you. Ah, right. Because that's what it sort of looks like when they're doing the protection detail.
Yeah.
Glanville's crew. All right, let me. So this doesn't have any new conditions.
It's literally the verbiage in, next to first couple of, conditions, I think the verbiage is just literally just a little bit.
Okay. All right. All right, it is right here. You bet. Deputy Gordon. No, I mean, it's not, I can mess, I was just gonna tell him I'm gonna go back there till something's ready, but I'll do something right here. Ms. Singleton, I don't know if you were just walking in or you're sitting in the back, but the juveniles are all here now. And Mr. Rhodes just spoke with his client, Mr. Horn. Ms. Cabrera came by. I don't know if you were in court when that
I
happened.
saw her, so I just sent an example of a transfer order to
Ms. Davis.
and to Ms. Cabrera.
Excellent. And we're going to do that plea the week of the 23rd. That trial that's going to go for a bunch of weeks is off the week of the 23rd. And so I'll be in trial, but at lunch or something on one of the days, we'll do Mr. Mender. And if we can get Mr. Francis in here, if Rogers is working out, we could do that one then too.
So those two definitely going back to me with just a reason.
Correct. I want to tell Mr. Mender that, but
Okay.
and yeah, same with Rogers. Horn, his lawyer just talked to him after having been in there, so maybe it's working out.
Thank you, Your Honor.
You're welcome. Can you bring Mr. Mender is Ms. Cabrera there? Oh, she's talking to him, then I don't need, that's all good. I just want to make sure someone talked to him about what's going on. Okay. Mr. Rogers. Oh. Hey, Mr. Rogers. You stay right there. Your lawyer, Mr. Francis, is in trial, actually right next door. And so we're not able to work on your case today. You were brought over because this was the trial calendar for your case. But Mr. Francis had already started another trial earlier this week. So if I can get his attention, I may have him poke his head in there to talk to you because he is right next door. So we're going to figure out if we can get you back here in a couple weeks with Mr. Francis to talk about the case. But I wanted you to know why you got brought over and why we weren't able to have a conversation about your case. Okay? Any questions? All right. Thank you. Deputy Gordon, I'm going to go back and get some work done. Let me know when lawyers say we're ready to do something. All right.
I'm good.
I'll take time down and come in. You need it? No.
Sorry. This is yeah, this one, yeah. Okay. I see, I said, well, this one, yeah, so one, okay, thank you, you're welcome.
He went down.
He went down,
He went over there, okay.
So y'all need to talk to us, it'll be inactive. I'm done with my business.
Oh, wow.
I'm sticking around just to see the show. Okay. Well,
Do you
I'm
need
gonna
help? No, I have two pleas and I'm ready on it, and so I'm gonna let them know. But because. Huh? Oh. Okay.
I was up. Alright. Oh, yeah. Yeah, I'm fine. No, thank you.
Yeah. The transfer file there. But whatever. So. Okay, so. This case. You agree with the person? Congrats. That's awesome. Okay, so I think. If you know, so we have a bigger trial, that's on this week. I don't really, but I don't know where, so I can act it, but maybe. Aggressive, thank you. Oh, what do you think? Oh. 4 days, that included jurisdiction. Yeah. Unless, I don't know if judge has a drug, so sometimes we use drug work on Wednesday mornings and trial week that we don't start until like 1. So that would be the only thing. It's a drug work.
But it goes like a bra, but you can pull out.
And that maybe. No, but listen, wait, listen, not sure, you guys are here. Yeah. That's what I will use. Here, yeah, but she's second job. So it should have this. And then this is the points. Yeah. We should try that. Was it? So yeah.
And which jurisdictions?
It's I can't even go as far as she got, so the. And so this one is. One second. Yeah. But it's a serious one. So yeah. It means it'll be downstairs. Downstairs.
Oh, he's downstairs? Okay.
He just walked in. He just walked in. I think it was the last year. So, yeah.
Yeah, that's keep it different.
These pieces, we have that, I'm thinking that I'm starting to join. Is that a good? Yeah. So we don't, yeah, because it's on my boss, yeah. So when he comes back. Yeah. Well, but I guess that's I want to write it over.
Is that the one? Yeah. I think she's about that. That was an option. Yes. Because I was like, who was the person? I don't know. I took it to the groups. I was like, I looked down there, so no, that was what it was. Yeah. I don't even know. Because I mean. So I guess. Yeah. I emailed them the terms of the lease. Oh, I don't know. Yeah, she emailed stuff. That's what I'm saying. Yes. Court was a oh, okay, yeah. Well, I guess we'll get. We'll see. Yeah, I don't, like I said, I speak my word. I don't think she's. Yeah, I feel like all my. So it's been a lot. Yeah, but like I said, I don't. Yeah. Williams. Oh, yeah, he's lucky. Oh, yeah, that was super fair. I mean, like, you said super fair. That was a fair sentence. Sure. Absolutely. Absolutely. You got lucky. That's what I said. I can be on my. Extra feedback. That totally does too. I mean, I'll help. Yeah, absolutely. That's. Which is all very. Two. It's a free bounce. So the 12 you don't know. So like yes.
Thank you. You know the code? 7.
Yeah. Oh, yeah. Oh. Good. I should have.
Okay. Yeah. Oh, you did? Okay. He's been there since December. That was 14-year-old. He is the funniest. And he will. Have you ever? I'm watching the video, like, it'd be great. And sometimes you got out. Good job. Good break. Unfortunately, that's just what happened. And so, yes, it's just a going to try to argue with the, well, the guy thought, the other guy took his phone, but that was his mistake. How did they can't argue the next minute? Then that's going to be for the jury to decide. We give that a young man, you know, so I'm saying that. Oh, yeah, it's taking. That's a long place. And you're trying to say you're not here. Barbed wire everywhere, you know, it's like a regular jail. Okay. It's spread out too. Okay. I can imagine spending, 7 months or something. You're 14 and incarcerated and
Ted says, Mr. Francis, please wait. Oh.
So. Later, y'all want to stay, and then we come back.
Yes.
Why'd you let
So he's being punished at 14 years of age. This is not, he's not being punished. But I think he had all the years.
I never, well, you can change it, but after that was one day, but that was, we haven't been that. Oh, that's what we're going to do. That's to me. The community. No, it could actually. Another. Okay, so it was pretty. Yeah, but it's not the sharing part there is okay, yeah, thank you so much. You're welcome. Yeah. I gotta give you that half an hour.
Oh. Okay. Hey, I think we have a resolution. They took him back downstairs, and I probably gotta go back over there.
Oh, no.
I see, y'all like, go get him, and then I gotta go back over there.
Well, he wants to talk to me.
Okay. Okay.
He was doing an email, he sent that first.
Okay, all right, great. Okay.
Did you notice?
Hey, how are you?
How are you?
Hey.
That was quite a jury selection. That was quite a jury selection. Someday you'll tell me what was going on there. Mr. Rogers.
I think we have a resolution.
Okay.
They,
Who are you looking to
Well, Mr. Rogers is not up right now, and that's because I'm running around.
I know Ms. Cabrera told me you guys had a quick break over there.
Right,
So is he gone, or he's just down? Okay, so we could bring him back if I don't know how big your window is.
yes, we're waiting on the jury.
Yeah.
I know the co-defendant is coming on the 23rd to take a plea.
The week of the 23rd, Ms. Cabrera told me that's a down week there. And so we could work I'll be in trial, but at a lunch someday that week, we were going to handle Mender.
Yes.
And so I'd love to handle Rogers.
Yes.
So we just work with your schedule.
Yes.
You and Ms. Cabrera can both show up.
Right.
We'll have Mender and Rogers here.
I'll have someone here.
Someone,
Especially
right.
said in Gwinnett.
For that 1 week in between?
Yes. So, I have a speedy one.
This is how you stay young. Well, same with Rogers.
It's not a get out of jail plea, so it's not gonna affect his time.
Okay.
But we just have further discussions.
And Mr. Rogers is in agreement with this?
No, I'm sure he will.
Okay, you'll get him there.
Very good offer.
Okay.
Very good offer. So we can put him on for the 23rd.
Well, the week of the 23rd, I don't know the date, but we'll communicate that to your team. You will have someone there, you will see him. We'll have Ms. Cabrera, her client, a stand-in for you.
Or Mr. Cabrera may even take the plea because they're not in the position.
Right.
And then we'll just waive any conflict.
Okay, however we do it, that address, because that's a speedy also,
Yes.
Mr. Rogers, and that gets that off your
Okay,
plate.
thank you.
And you heard Mr. Tewitt has a new lawyer now, Ms. Fagan.
Yes.
Yeah, so also off your plate. We're just taking stuff off your plate. Anything
All right.
else?
Thank you, Judge.
Yeah, okay.
All right. Okay, good. You got my number? Yes.
See ya.
All right, Ms. Rios, I've been told you have 2 pleas. What would you like to do first?
Dane first.
Mr. Dang, all right, come on up to the podium, please, sir. Ms. Davis, did you and Mr. Slayton get to speak at all? I know you had about 100 lawyers back there. You're probably ready to rinse off, but you guys did get to talk? Good.
We are still kind of at an impasse there.
Oh, I didn't think that was going to change. I just knew he wanted to bend your ear.
Oh, yeah, definitely. He did.
Okay.
Some statements, things about living.
All right, I'll be here. One second. Mr. Rhodes, tell me if there's a plan for Mr. Horn
Yes, Judge, I believe that will be.
today. Great. We can do it after we take Mr. Dangs. Okay, Ms. Rivers, are you ready to go?
Yes, I am. Good morning.
Good morning. All right, Mr. Dang, good morning. You are in court with your lawyer, Ms. Rios. Ms. Davis is here for the state, and your case is actually on 2 calendars, but today's trial calendar, you are position 21. It is indictment 24 SC 005787. And Ms. Rios tells me that you're prepared to enter a plea. Is that correct? Okay. Ms. Davis is going to put you under oath in a moment, ask you a bunch of questions. You need to answer those questions. You also need to let me know if you have questions of your own. If someone says something that confuses you or is not going the way you thought it was, tell Ms. Rios or tell me. Will you do that? Okay. We're ready, Ms. Davis.
Mr. Dean, can you please raise your right hand? Do you swear or affirm the testimony you shall give the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
E.A. Dang.
Can you please spell your first name and last name for the record?
First name A-T-H-I-E-Y, last name D-E-N-G.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken this morning?
No, ma'am.
How old are you and how far have you gone to school?
23 and I graduated high school.
What high school did you go to?
South Atlanta High School.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that you are charged with the following offenses? Judge, we are doing a departure from the charge of armed robbery to robbery,
Okay.
aggravated assault, and possession of a firearm during the commission of a felony.
When you say departure, meaning you are reducing armed robbery to robbery.
Yes.
Got it.
And do you understand that you were charged with those following offenses?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding the indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney? Are you satisfied with your services?
Yes.
Do you remember having been arrested on these charges? Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Rios, are you aware of any outstanding warrants related to these charges? No. Has your attorney advised you of the minimum and maximum sentence to which, for each charge to which you're pleading to today? Mr. James,
Excuse me?
has your attorney informed you of the minimum, which
Yes.
is the lowest you can be sentenced, and the maximum possible sentence?
Yes, ma'am.
Do you understand the day that you are entering a negotiated plea of guilty, which means that the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence? Do you understand that the court has a right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you're pleading today, and the court has a right to run those sentences consecutively, which is one after the other? Do you understand that the court decides to, excuse me, that part. It's my understanding that you're entering this plea under first offender, or you're asking the court to consider you as a first offender. Is that correct?
Yes, ma'am.
Have you ever pleaded guilty or not to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for a crime, felony, or misdemeanor under the First Offender Act? Has your lawyer explained the First Offender Act to you? Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced up to the maximum sentence for each charge on the indictment?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing or other convictions in this jurisdiction, as well as other jurisdictions, including federal courts?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else? Do you understand that by pleading guilty to a felony, you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony which may carry a sentence from 1 to 15 years in prison? I'm just gonna ask you to speak up, and we do have a court order online. Okay, thank you. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to possess or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any potential mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes.
the right to the assistance of counsel hired by you or court-appointed counsel if you cannot appoint an attorney at the trial of your case,
Yes, ma'am.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal convicted of these charges after a trial.
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to the charges in indictment 24 LC 005787 to the charge of robbery, aggravated assault, and possession of a firearm during the commission of felony?
plead guilty.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Judge, I'm not sure if your courtroom allows it, but I believe counsel was going to stipulate to the facts of this case. Yes. Or would you like me to go through the case right now?
I think I remember a bit about this. I'm not sure what the hearing was about, and maybe it was modifying bond, but Mr. Dang worked somewhere, felt that he didn't get his final paycheck or didn't get paid enough, and there was a altercation with Mr. Serco, who is the victim in the case that resulted in these charges. It was a dispute over, you either didn't pay me for all the hours I worked, or we agreed to a different rate and I wasn't paid at that amount. That's the sort of gist of it? Okay. I do think there's a factual basis for the plea.
Judge, at this time, we have agreed to a negotiated sentence for this individual based on some conversations that we, of course, have had with the Next Level Boys Academy. I believe Mr. Davis, who runs that program, will provide a little bit of background. He's had an opportunity to work with Mr. Dean over the last 3 months. Mr. Dean has no criminal history. This is first offense. And so we are asking the court to consider a kind of back-end sentence where overall you will be sentenced to 10 years probation. A portion of that could be served in custody if he does not follow the terms. So for the first 5 years of probation, if he follows all the terms which I will outline and he does not get into trouble, then he would not need to serve any time, and his probation will be terminated at that time. We are asking that he do 150 hours community service total, with 80 hours to be completed on the first year, 70 hours to be completed on the second year. For him to participate in the program with Mr. Davis for 24 months. That program is typically 12 months. Correct? Sorry, Mr. Davis has agreed to extend it to 4 months. He does have his GED, so he would not be required to do that. And I believe Ms. Rios don't miss any other conditions.
That's all. And a letter, an apology letter.
And an apology letter to the victim. Thank you.
I'm looking at your email. Okay, yeah, that all matches up. I'm going to probably structure the sentence a little differently, but I think I follow what the recommendation is. Let's hear from Ms. Jackson. Good morning, Ms. Jackson.
Good morning, Your Honor.
Do you have any criminal history information for Mr. Dang?
There are no prior arrests on file, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. Mr. Dane is 23 years old. Him and his family were originally from South Sudan. They were displaced because of the war stuff that was happening as they went to Ethiopia, where he was born in a refugee camp. And then they came to the States. He lived in Clarkston, Georgia, and later Fulton County. He graduated from high school in Atlanta. He is currently signed to a modeling agency, Next Model. I believe he was just out doing some shoots in a Labor Night. And he also is a clothing designer. His family is here. He has his mom here, his brother and his brother-in-law. They come to pretty much all the court dates and support. I've talked to all of them several times. They've been very invested in him and keeping him out of jail or prison, Your Honor. I don't think prison would be, I think he is on a good track. He didn't have anything before this incident. Nothing happened after this incident. This took place about 3 years ago. This was a situation where he let his impulses get the best of him and made a very, very big mistake. This wasn't a situation where he just found someone on the street and decided to rob him. This was, a very specific thing. And I think had it not been for that interaction, that he would not have had a history of not have had interactions with the law overall. I do want Mr. Davis to come and speak. Mr. Davis?
Good morning, sir.
Morning.
So tell me a little bit about, it sounds like Mr. Dang is already working with you.
Yes, sir, he is.
How's he doing?
He's doing amazing. I met him about 3 months ago. And I did my interviewing process with him to be accepted to the program. There's a series of questions that I asked. Not only what were you doing prior to this, what were you doing when this took place, and where we're going with this. And just the progression in life. And what's made it a lot more easier to work with someone like him, amazing young man, beyond amazing. And what makes it easier is that he's already has goals set. And I've taken it upon myself to mentor him. So he's with us 3 times a week. He'll have mentorship twice a week. So give us about 5 contacts with him a week. And I was very clear with him and his family that if you're granted this opportunity, you don't take advantage of it. But the working relationship that I have with the courts and with probation, we will report you. I doubt very seriously. I've been doing this long enough to know that this is a shocker that he's in this situation. The young men that I typically work with, you kind of like, but with him, with all due respect, I think this is a very unfortunate situation for him to be in.
Okay, thank you. I appreciate the services that you provide and that you're here today on his behalf.
Yes, sir.
Ms. Rios, anything else?
No, I just actually go along with the plea that we negotiated.
Okay. Ms. Davis, has your office been in contact with Mr. Serco?
We did reach out to I attempted to reach out to him as well this morning to make him aware of it was off. Not aware of it this time, but I don't believe this is the best interest.
Okay. Do you have a position on first offender status for Mr. Dang?
I am not opposed to it.
All right. Mr. Dang, is there anything you want to add? What was the job you had with Mr. Serco?
Security at a movie set.
A movie set. Okay. Security, like armed security, or you just were making sure people stayed away or were where they were supposed to be?
Letting people enter and out the gate.
Okay. And you now tell me what you do for work. I heard what Ms. Rios said, but put it in your words.
Right now I'm doing fashion model and runway model, and I usually just go to New York or California to just do work out there at small brands or large brands.
Okay. If you are on probation, traveling out of state doesn't just happen. You need to get permission in advance to travel out of state. You understand that? So that's not me saying, no, you cannot. It just means if you know that you're going to LA or New York before you go, before you commit, you need to reach out to your probation officer so that that person can say, great, show me the itinerary. You're going to be gone for a week or a day or however long it is. And it shouldn't be a problem getting that approval, but you need to make sure that you get it. If your probation officer learns after the fact that you went to California, that's the kind of thing that's going to start to get you in a position where you don't want to be. Does that make sense? How often would you say that you travel out of Georgia?
2 times a month.
Okay, and how long is a typical trip?
4 or 5 days.
All right. Well, it's doable, but it's going to require you to plan in advance, which I'm sure you have to anyway. It's not like you just get a call saying, run to the airport right now. They give you a little notice so you can plan. And your next call after your agent or whomever reaches out to you would be to probation saying, here, I'm going to email you the itinerary. Here's the plan. And if that goes smoothly, then I think going forward, it'll be pretty easy for you to get that approval. Okay. Any questions about that? All right. And what do you do if you're out of town? How are you doing your Next Level Boys Academy work?
Virtual, but Saturdays is in person.
Okay. So you figure out a way to stay connected even if you're out of town. All right. Any questions about anything so far? All right. Well, Mr. Dang, I find that there's a factual basis for your plea. I do think this was a one-off situation where a young man, pretty young at the time, didn't exercise proper impulse control. You were angry, and the way you managed it was dangerous. It's the kind of situation where, in theory, Mr. Serco could have said, well, my gun's bigger than your gun, and he pulls it out, and someone gets real badly hurt. I trust you've learned from that. For the entirety of your sentence, you can't have a gun, can't have one on you, can't have one in your household, can't drive in a car with guns. So I don't know what fashion and entertainment and whatnot means for you, but it needs to not be on sets where people are brandishing guns. That doesn't mean there can't be security on the set, but you and the people immediately around you need to not be carrying guns. Does that make sense? All right. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means you've understood everything we discussed. Do you agree with both those? You're being sentenced pursuant to the Probation Options Management Act, which means that for the time that you're on probation, if you have a small violation, you and probation will figure out what to do with that. But if it is a significant violation, so any arrest, anything like that, that comes back to me and we'll work through the consequences. Ms. Rios, can someone in my office sign the indictment on behalf of you? Ms. Davis? Mr. Dang, is it okay if we electronically sign your name to the indictment indicating your first offender plea? First offender is an opportunity for you. You qualify for it. This is the only time you've been in trouble. And that means that you have the chance to have this case not forever on your record. If I sentence you as a first offender, when you leave here today, you don't have a conviction. So if someone's asking you, hey, do you have a felony? The answer is no, even though you're under sentence. It's a great opportunity so you can continue to be an entrepreneur and do what you want to do. There's a risk to first offender, though. You are only 23, and while Mr. Davis and others are serving as mentors in your life, you still can mess up. And I'm letting you know now that if you end up getting in trouble for something, in particular something involving guns, while you're on this sentence, we will have a hearing, you'll have a lawyer, but I would be able to not just revoke your probation, but to resentence you, not as a first offender, but as a felon. And given what you're pleading to, I have 45 years to work with. Those are big numbers. That's double your life. And so just by way of example, if 2 years from now we're together again, you pulled a gun on someone, and the state proves that up in a hearing that you pulled a gun on someone, I would very likely take away your first offender status and probably sentence you to 10-ish, 12-ish years in prison on this case, not on the new one. You'd still have that new case as well. So first offender leaves you with a whole lot of exposure. But that's a very, very small risk if you have figured out that what happened in October of 23 is a one-time thing. Something like that won't ever happen again. But you know that better than Ms. Rios, your brother, Mr. Davis. You know that best of all. Do you think that first offender makes sense for you? Okay, then I'll sentence you as a first offender. Mr. Dang, I am sentencing you as follows. On count 1, I'm sentencing you to 5 years. Count 2 is 5 years. Those will run concurrently with each other, and they are probated. Count 3 has to be 5 years. It has to run consecutive, and I'm sentencing you to 5 years in custody. So it's a funny sentence. I don't mean funny to make light of what's going on. What's going on is very serious. It's a peculiar sentence because it starts with probation, 5 years of probation. It ends with 5 years in prison. But what I'm saying now is that if those 5 years of probation go well, then I will amend your sentence and turn those final 5 years into suspended. So you're not on probation, they're just sort of out there. And the only condition of that suspended sentence would be that you obey the laws of Georgia and all the other states and the United States. You do have some conditions for your probation, those first 5 years. Number 1 is that you write an apology letter to Mr. Serco. You don't send that to him, you're going to end up getting that actually to the district attorney's office. So you get it to Ms. Rios, she'll get it to the prosecutor, they'll get it to Mr. Serco. Number 2, you're going to do 150, it's a lot of hours of community service. At least 80 have to be done in the first year. It's a long time to get that done. And then the remaining 70 have to be done in the second year. I encourage you to work with your probation officer to come up with creative ways to do the community service. If you simply say, give me some community service, you may end up picking trash up on the side of the road, which is great. That road will look nicer, but that is a waste of your talents and I think your life experiences. If you and your probation officer work together, you might be able to teach, you might be able to mentor, you might be able to give back in ways that are fulfilling, not just for you doing your community service, but to the people who receive that community service. But that's on you. If you're passive about it, you're going to end up scrubbing floors or picking up trash. And that's fine. That'll keep you thinking about not pulling a gun on someone. But I think you could give back more. So think about that. But it does need to be community service. It doesn't count to do a free modeling show for someone and say, hey, I won't take a fee for this one. Nike, you keep the money. That's not community service. Okay. I think I covered, and of course, there's the Next Level Boys Academy. And you need to complete a full 24 months. You've already done some and you'll get credit for that. But it's a full 2-year cycle unless Mr. Davis concludes it's just there's not a point in continuing to do it because you've reached a point where you should be teaching the classes rather than being in the classes. And so I will generally defer to Mr. Davis. If he comes back too soon and it's less than a year, I'll say, no, I want you to continue to be an influence in Mr. Dang's life. But if we get to the 1-year mark and Mr. Davis said, it's just now we're trying to squeeze blood out of a turnip. It just, Mr. Dang is exactly where he needs to be. I'm happy modifying that condition. Okay. Again, this is a strange sentence. It's 5 years probation. It's a chance for you to prove up what Mr. Davis is saying about you, that this was a one-time aberration and that's never going to happen again. If those 5 years go well, then the final 5 years become a suspended sentence. No probation, nothing. But if it's bumpy, you're getting arrested, you get kicked out of Next Level Boys Academy, anything like that, then those last 5 years, they're hanging over your head pretty heavily. Does that make sense? Okay. Do you have any questions about anything I discussed? Ms. Rios, anything else on behalf of Mr. Dang?
When it's in the disposition, will it be put that like specify the return to suspended? I'm just worried like if someone, you can leave us somehow and then.
I leave you?
I mean, like not die.
How?
Like, no, wait.
What do you know that I don't?
Like they'll be the next judge if something happens.
Understand. Yes, I will make sure. This is a first for us, but Ms. Nelson is going to take a swipe at it. She'll get the final disposition to me, and I will make sure there's language in there that makes plain that if the 5 years of probation are successfully completed, the 5 years in custody become 5 years suspended. So it's not left to the whims of my successor, should there be one soon. So we'll see.
Since you're wanting to do the complete 5 years,
Hmm?
can you include, no early termination?
Yes, but query whether, and maybe this is more, I'm not putting the state on the spot here. If we want to do a behavioral incentive date and say, well, how are things going in 3 years?
Our system automatically kicks in, it'll send the officer and say, hey, as long as nothing demanded, mathematically, he's eligible.
Okay.
Because he's first offended.
Okay, then I won't set a behavioral incentive date. I am open to having us reconvene in 3 years if things have gone really, really well. And at a minimum, what I might do after 3 years is to say, let's turn those 5 years in prison into more probation, so that in case I am replaced, then that's cleared up then and there, that it's a purely probated sentence, and then probation might end early depending on what happens. So, so you wanted me to say in the final disposition that at least now all 5 years are to be supervised.
Or either just put in, you can either do it that way or do the no early termination.
No early.
If you want to leave that window open, then he'll just be mathematically system or our system wise.
Okay, I don't want to foreclose early termination as long as it's a group discussion.
Well, I mean, it's gonna have to come to you anyway.
Right.
So we can reconvene at that point then.
Okay.
Agree or-
Okay, why don't we do that? All right. Ms. Davis, anything else?
No.
All right, Mr. Dang, When you are here in Georgia, what county do you live in?
Fulton County.
All right. You need to spend a little time with Ms. Simpson, who's with probation. She's going to give you reporting instructions. Make sure you don't miss your first date, because if you do, they send me a warrant, and boy, we've started off on the wrong foot. So she'll let you know where you need to be and when you need to be there. And that'll get you plugged in with probation. And let that probation officer know the first time you're meeting with him or her, hey, I travel a lot. And we can develop a routine so that, assuming it makes sense for you to be out of state, you're able to do those trips. Okay? All right. Thank you, everyone. Yes. It's 40, 16840. Mr. Rhodes, you ready? All right, Ms. Davis, you ready to pivot to Mr. Horn? Do we have an update on Ms. Gladden? I know we do on Ms. Taylor. Ms. Taylor is en route and is going to be here probably in about 10 minutes. What are you hearing about Ms. Gladden? Still pulling in. Okay, you're here. That's the important part. And we're going to reach out to her again to see what the heck's going on. All right.
If I may, for 1 minute, and this one comes out explaining a few more finer details.
Sure. And then we can do Mr. Edwards after Mr. Horn. But I think Ms. Rios just stepped outside. That's okay. She's not late. We got one plea ahead of you. Is he getting him?
Yeah, he's.
Oh, he had to be in a different space. Oh, because they're,
Next door.
how many defendants do they have?
3.
Okay,
They have a female and 2 males.
okay. Are we good? Yes. All right. Good morning, Mr. Horn. How are you? All right. Mr. Horn, I'm Judge McBurney. We met before. Mr. Rhodes tells me that you're prepared to enter a plea in your case. Is that correct? Okay. The way that's going to work is that Ms. Davis, who is seated to my left, she's the prosecutor in your case. She's going to ask you some questions about your rights. You're a criminal defendant, and you have rights to trial and rights to an attorney, things like that. Things Mr. Rhodes has talked to you about. I need you to listen to Ms. Davis's questions and then answer them to the best of your ability. If she asks you something that you don't understand, I need you to tell me that so we can ask it in a different way until you do understand it. Will you let me know if at some point you're not understanding what's happening? Okay. She's eventually going to make a recommendation as to what your sentence should be in this case because you're pleading guilty. Then I'll hear from Mr. Rhodes on your behalf. And then you may have something you want to say. You don't have to say anything at all other than answering questions, but there'll be a time at which I turn to you to say, is there anything you want to add? Because if there are things you've been wanting to say about this, you'll get a chance to do that. But like I said, you don't have to say anything other than the answers to the questions. Does that make sense? Okay. Then what we'll do is get started. This is 25 SC 000816. You are Tyler Horn. You're here in court with your lawyer, Mr. Rhodes. Ms. Davis is the prosecutor, and I'm going to turn it over to her.
Please raise your right hand. Do you swear or affirm that the testimony you will give in this matter should be the truth, the whole truth, and nothing but the truth?
Yeah.
I'm gonna put your hand down. Please state your true and correct legal name for the court.
Tyler Horn.
Are you at this time under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone to school?
15 years old. I'm in the 8th grade.
The 8th grade? What school did you go to?
We got middle school.
Are you able to read, write, and understand the English language?
Yeah.
Are you a United States citizen?
Yeah.
Do you understand that you're charged with the following offenses? And Judge, the state is going to move to null pros the armed robbery offense. And we are just proceeding on count 2 and 3, which is aggravated assault and possession of a firearm during the commission of a felony.
All right.
And Mr. Horn, do you understand that you're now charged with aggravated assault and possession of a firearm during the commission of a felony?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. It's got to be out loud for the court.
Yeah.
Have you had enough time to speak with your lawyer?
Yes.
Mr. Rhodes, have you discussed all the facts and circumstances known to you about this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with the services?
Yes.
Do you remember having been arrested on these charges?
What's that?
Do you remember being arrested for this case?
Yes.
Judge, the state is unaware of any outstanding warrants related to this case. Mr. Rhodes, are you aware of any outstanding warrants related to this matter?
No.
Mr. Horn, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today? The aggravated assault has a minimum 1 to 20 year sentence, and possession of a firearm is maximum 5 years sentence consecutive. Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has a right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that there are multiple charges to which you're pleading to today? The court can run those sentences consecutively or one after the other.
Yes.
I'm not sure we did discuss this. Is your client pleading under first offender? Or is he?
We can discuss it. Judge, may I again have actually another 2 minutes?
You can, let's, yeah, let's talk about it at the back end because I'm nervous about doing a first offender, for Mr. Horn. So let's get through what the sentence might look like and, get Ms. Singleton in the loop. And then I won't forget to address it, but I'm not sure that I think that's an option I'd be pursuing in this case.
All right, Mr. Horn, do you understand that this plea may be used to enhance sentencing of other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that is true regardless.
Yes, ma'am.
Yes.
Did you leave her a message?
Hold on, that's not you. That's, that was, I think, Ms. Hansberry of all people. So guest appearance by Ms. Hansberry. Keep going.
If you're not a United States citizen, it will result in deportation, just like a conviction at trial would, and that's true regardless of any advice given to you by anyone else, including your attorney. Okay. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes.
Do you understand there may be other adverse or unfavorable consequences as a result of the guilty plea conviction, just as there would be from a conviction following trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that you waive any and all offenses, including mental health offenses, by entering a guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand that you may?
Excuse me,
Hold on.
I need the defendant to speak up.
Okay,
Yeah, you have to raise your voice a little bit.
outside voice.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today for the felony charges to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
How do you plead to indictment 25 SC 00816 to the count of aggravated assault and possession of a firearm during the commission of a felony?
Yes.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Is this guilty plea freely and voluntarily given, full knowledge of the charges against you?
Yes.
Judge, we'll go over the facts which show at trial that on November 26, 2024, at about 11:22 p.m., officers from the Martin Police Department were dispatched to a shots fired call at the Martin Midtown location station at 41 10th Street in Atlanta, Georgia, and Fulton County. Officers observed the victim, Mr. Udon Holly Jr., who was bleeding profusely from gunshot wounds to his right hand and left inner thigh. CCTV surveillance footage captured the events leading up to the shooting. The video shows a group of individuals, one of those individuals including Mr. Tyler Horn, who congregated at the southbound platform near a bench where Mr. Holly was seated. There was a brief altercation. Mr. Holly, who appears to be, grabbed a cell phone and a charger. That cell phone did belong to Mr. Horn. That's why we don't cross the first charge, because it was his property. But afterwards, Mr. Horn is seen on video shooting Mr. Holly and then disposing of the weapon in a trash bin. We have been negotiating this case with defense counsel and considering the facts and circumstances. We have come to a negotiated agreement asking the court to consider 15 years total, with 5 of those years to be served on probation. That Mr. Horn participate in a program, whether that be at Promise Center or Next Level Boys, that he complete his GED and do 60 hours community service. Also considering that Mr. Horn is underage, it's my understanding that he would come before the court when he turns 17, and there will be an opportunity to evaluate how he has been doing in custody and make a decision moving forward about whether he proceeds to the Department of Corrections.
So your overall recommendation is 15 to serve 10, balance on probation.
15 to serve 5.
Okay, I misunderstood. That's okay. So 15 to serve 5, so 10 years on probation. Okay. All right, and obviously credit for all the time that Mr. Horn's been in. Got it. Okay. Ms. Jackson, I'm assuming you have no information on Mr. Horn. He's 15, but you dig deep when you're researching. Ms. Jackson, are you there? Uh-oh. We'll see if she rejoins us. Ms. Singleton, do you have any juvenile history? I think some of this we discussed when we were working through bond, so this will be refreshing my recollection. And Mr. Rhodes, you weren't counsel of record then, so this may be new for you, but let's hear what Ms. Singleton has.
The defendant has an August of 2023 case that was transferred out of Rockville for carrying a weapon in the school zone. That weapon was a knife. The defendant has a December the 23rd of 2023 criminal trespass, which was breaking into a car. He was adjudicated delinquent by plea for that. And the first case, Your Honor, he was also placed on probation for that. That probation was transferred to Fulton. He has a January 24th of 2024 theft by receiving felony, which was a Kia, and possession of tools. That was a screwdriver, Your Honor. He's continued on probation. And he has a February the 3rd of 2025 shoplifting misdemeanor target and possession of a handgun by a person under 18.
That date confuses me. 2025, he would have been in custody. It just caught up to him.
Yeah.
So the dates you shared with me are dates of disposition, not like the August of 23, December of 23. Those are disposition dates, not incident dates.
Those are incident dates.
Oh, but this most recent date you gave me is a disposition date, the shoplifting.
That's also an incident date.
But in,
Well, that's the date that it was filed in. I see what you're saying.
okay, because he would have been in the YDC
He was
in,
arrested, well, he was served with these warrants on February the 4th. So he was in custody on that case when they realized he was in custody and went to the, contacted me and then went to the facility and served him.
okay, got it. All right, I appreciate that. Mr. Rhodes, what do you want to add?
Yes, Judge. As you're well aware, Mr. Horn is 15 years old. He was 15 at the time of the incident and is currently still 15. This case was initially brought before Your Honor due to the armed robbery, which has since fallen away and all crossed. We're asking the court to accept the sentence as negotiated. We believe that the sentence would, as you heard, he has had run-ins with the law previously. But we believe that the sentence would give him a good chance to redirect himself, recalibrate himself. He's already had a good amount of time to think about the actions behind this incident. He is remorseful, and during his time at the YDC where he's at now, it's been my understanding that he has been behaving well. He's received certificates as well from the officers there. But yes, Judge, part of the conditions as negotiated, I believe he'll be a part of the next level of Boys County. He'll be required to receive his GED. He will be, forced in a way to be on a straight and narrow and, redirecting his life. So again, we would ask the court to accept the sentence as negotiated. Again, knowing and hopefully, as A.A. Davis has noted, just before 17, he may be brought up to court again to reconsider and analyze the sentence. I've explained that to him as well, and it's our hopes as well that during his time at the juvenile detention center serving the sentence, the beginning of it at least, that he will be on good behavior there as well. So again, I'll leave it at that, Judge. We just ask that you accept the sentence as negotiated.
Okay, I appreciate your service. Ms. Singleton, sometimes you have visibility into a second category of situations, and that is how a juvenile offender is doing at the YDC. Do you have any information there about how Mr. Horn has been doing? Model student, often in fights, somewhere in between?
Reasonably well. We had an incident yesterday, and it's my understanding that was the first incident he had while he's been there, which was a fight.
Okay.
But other than that, they have no concerns about it.
Okay. And in terms of the sentence I impose, Mr. Horn is being prosecuted by the state as an adult. So I'm imposing the sentence that I think is reasonable, which seems to be along the lines of what was negotiated. But Mr. Horn will serve the initial portion of it at a YDC until he reaches 17 or just before. And then, as several people have pointed out, we'll have another hearing to see what happens at 17. Sentence keeps going and Mr. Horn moves to an adult facility. Sentence is modified. Maybe he's released to supervision, but that will occur automatically.
I typically send an email to the litigation manager about a month and a half before the 17th birthday requesting the court date.
Got it. Okay, so we'll get that notice and be able to bring everyone together for that.
Yes.
Okay, thank you. Mr. Horn, do you have any questions about anything people have been talking about? Do you have anything you want to add? All right, well, Mr. Horn, I find there's a factual basis for your plea. I've watched the video. It's pretty clear what happened. The main thing I've learned from today was that it was actually your phone that you and your friends were trying to get back. So you weren't robbing anyone of anything. You were getting your own property back. That's a relief. What's not a relief is what happened after you got your phone back, which was shooting this guy who was literally just sitting on a bench. And that's the part that is disturbing and concerning and the reason why we're still working through this case. So I do find there's a factual basis to a plea to aggravated assault and possession of a firearm. I also find that your plea is voluntary. That means that no one's forcing you to do this. You've had a chance to talk with Mr. Rhodes about it, maybe with family, but importantly with your lawyer, and you've decided you're ready to enter a plea. Is that right? And a knowing plea just means you've understood what we've been talking about. And you told me you don't have any questions. Is that still the case? All right, then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that when you get out, by then you're going to be 17 or older, and you'll be on probation for a while. While you're on probation, if you have any trouble on probation, if it's small trouble, you and probation will figure out what to do. But if it's something more serious, you get arrested again, that comes back to me and I figure out what the consequences are. Mr. Rhodes, is it all right with you if someone on my staff signs the indictment on your behalf?
Yes, sir.
Ms. Davis?
Yes, Your Honor.
Mr. Horn, can someone in my office electronically sign your name to the indictment indicating your plea to the aggravated assault and the gun charge? We're going to do that. Question came up, Mr. Horn, about first offender. I don't know if you know what first offender is, but it is a way a judge can sentence someone if they don't already have an adult felony conviction. And you don't because you're only 15. But it's not something that I'm going to do here. And I just want to put on the record why. There are a couple reasons. One, you have enough that's gone on as a juvenile, based on the information I got from Ms. Singleton, that I don't think it's appropriate. But more so, I am worried about the effect it would have on you if you have a difficult transition when you get out. Because someone who has first offender who gets in trouble again, not only has the new case, but that first offender can be taken away and you get resentenced. And you got 25 years you could be resentenced to in this case. And I just don't want to set up that tripwire for you. So I'm not going to sentence you as a first offender. I will follow the negotiations in this case. On count one, I'm going to do nothing because that's been dismissed by the state. On count two, I'm sentencing you to 10 years to serve 5 years with a balance on probation, and you'll get credit for all the time you've been in. Count three has to be 5 years. It has to run consecutive. I'll probate those years. So it'll be a total sentence of 15 years to serve 5 years with a balance on probation. A special condition of your probation, if you haven't done it while you're in custody, will be to get your GED. You'll also need to complete 50 hours of community service when you get out. You'll need to do that in the first 6 months. You are on parole or probation. And the last thing, and this is not part of your sentence, I'm just repeating what you've already heard. In less than 2 years, we'll be back together because you'll be approaching your 17th birthday. And I'm required by law to have a hearing at which I'll hear from Mr. Rhodes and Ms. Davis or another prosecutor and Ms. Singleton about how things have been going for you, good, bad, messy. And the reason for that is twofold. One, it's an incentive for you to try to stay out of trouble while you're at the YDC. Because if the report I get is, hey, Mr. Horn finished high school, he didn't get in any trouble, that tells me you're heading in the right direction. If the report is different, that tells me you're not quite ready yet to be back in circulation. But it's also important just to have a check-in because of your age. You are still growing up, and we'll need to see how things are going just before you turn 17. So that's where we are. Mr. Rhodes, anything else on behalf of Mr. Horn?
No, please.
Ms. Davis? Ms. Singleton, anything more I need to say about the sentence to make it go into effect just because we're working with a minor? Okay. So Mr. Horn, that's the situation. I will see you a little bit before you turn 17. Any questions about anything? All right. Thank you, everyone. Yes, thank you for your work on the case. Thanks, Ms. Singleton. It sounds like Rogers and Mender will be dealt with at the same time. In fact, Ms. Cabrera may handle them both. We just don't know yet when, but it will be the week of the 23rd. It'll be a lunchtime one of those days, not Monday, not Wednesday.
Okay.
So we'll work with your schedule too.
Special language from this,
Singleton?
Singleton on this sentence.
I don't think so. There's not, because he's not being released, it's not like a bond order where he's being released to your supervision. I don't think there's any technical language that needs to be in the final disposition. It reads just like we discussed. You will trigger the age 17 review just by letting us know, hey, he's approaching that milestone.
That's correct, Your Honor. Then if something changes, then it would.
Okay.
Then the language gets complicated. Okay. All right. Thank you. Ms. Rios, are you ready on Mr. Edwards?
You need a,
Oh, you're right there.
She didn't go anywhere. Ms. Wood, do you have anything else today?
You know, Doug, I'm just looking moral support.
We appreciate that. I need, please, the case number of Mr. Edwards's probation case.
17 SC 153046.
And does he have is there a petition or a warrant, or he's gonna agree to waive notice and we handle it today? How much,
There was a warrant issue.
even though this case has been out for all this time?
I made the same reference.
Lucky Mr. Edwards. How much time is left on the 17 SC?
His probation doesn't expire until February 2014.
Oh, what's that case about? I'll look it up.
I believe it was a possession of intent, is.
Another drug case.
Yes, yes.
Okay. So he has like 23 years left on probation. Okay. All right. Well, let's get on the record. This is 24 SC 003229, State versus Edwards. Mr. Edwards is in court with Ms. Rios and Ms. Davis is representing the state. Mr. Edwards, you ready to enter a plea?
Yes, sir.
Okay. Ms. Davis will put you under oath, ask you questions it sounds like you've heard before. I need you to answer truthfully, and I also need you to let me know if you've got any questions of your own, okay? All right, Ms. Davis.
Please raise your right hand. Do you swear or affirm the testimony you shall give us matter before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your true and correct legal name.
Dante Marquiso.
Can you spell your first and your middle name?
EANTE-MARQUIES.
Thank you. Are you at this time under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone to school?
43. 10th grade.
And what school did you attend?
The last time was down academy.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you are charged with the following offenses? You're charged with trafficking and illegal drugs, and Judge, we are no crossing count 2 possession of a firearm during the commission of a felony.
Okay.
Do you understand that you're charged with trafficking and illegal drugs?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Rios, about all the facts and circumstances known to you regarding this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with their services?
Yes, ma'am.
Do you remember being arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Attorney Rios, are you aware of any outstanding warrants related to this matter? Mr. Edwards, has your attorney advised you the minimum and maximum sentence for the charge to which you are pleading to today?
Please. Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means the state will recommend a sentence to the court?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on the charge?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Excuse me.
Do you understand that this plea, by entering a plea, it may be used in the future to enhance sentencing, increase sentencing in other convictions in this jurisdiction as well as others, including federal courts?
Yes, ma'am.
So if you pick up additional charges in the future, this plea could be taken into consideration.
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, if that is true regardless of any advice by your attorney or anybody else?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which can carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment. So, do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty? Do you understand by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial in your case,
Yes, ma'am.
the right to the presumption of innocence,
Yes, ma'am.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
the right to appeal and convict of these charges after a trial.
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead an indictment 24 SC 003229 to the count of trafficking and illegal drugs?
Guilty on behalf of.
Has anyone forced, threatened, or promised you anything to get you to enter this plea?
No, ma'am.
Is it your decision to waive these rights and enter this plea because you're in fact guilty
Yes, ma'am.
under oath? Okay.
On behalf of.
Is this freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, we believe that the facts at trial would show that officers have obtained a search warrant for the property located at 1056 Dill Avenue in Atlanta, Georgia, in Fulton County. The officers did knock at the door, wait for someone to answer the door. Mr. Edwards was at the property, but he was at the rear of the property. Officers located drugs in plain view throughout the house. They did not find any drugs on Mr. Edwards' person. However, they were all throughout the property. The GBI tested many drugs, but it does meet the minimum required amount to.
Does or does not?
Does.
Okay.
It does. There is a 24-page GBI test result. And counsel said that she was stipulated to step down, but it did meet the minimum amount for the drugs that were located on the property, and I'm just going to be, it was methamphetamine.
Okay. Trafficking has a mandatory minimum. Are you reducing this to possession with intent, or is it a plea to trafficking?
I'm glad you said that, Judge. Yes, we will be reducing it to possession with an intent so that this can be a probated sentence as we negotiate with counsel. They did point out some things in our case. So with that taken into consideration, we are asking for a straight probated sentence.
Okay. Of how many years?
It would be 10 years probation, Judge.
Any conditions?
We would refer the court on the conditions of this case with the understanding that he is already on probation, and I don't want to make things overly burdensome or duplicate any conditions that already exist.
Okay. I'm looking at the conditions in the previous case. Did you get your GED?
Recommend them.
Okay. What does that mean?
Trying to find time and the program to get into it, because that's my aunt who got dementia. And I got a daughter who's a full-time student in college, and I'm trying to keep motivated. She just made something.
Good for her. Where's she going?
Fort Valley University.
That's a good school. Judge LaGrua included a fine. Did you end up paying your fine?
Like, I barely have time to even do anything because my aunt, because she's 86, and, you know, it's a lot going on with her.
Okay.
Like, I had to wait. I was late today because I had to wait for my aunt to come, and we had a situation with my aunt and my other aunt. I got two aunts that's still alive.
Okay.
The oldest aunt is a good child of the family, and she was just, it was one of those rough mornings this morning. So I had to wait for my other aunt to get there so she can watch, so I can go down and come in.
Okay. Ms. Rios, what do you want to add?
Mr. Edwards is 43 years old. He is from Atlanta. And I, as he mentioned, lives with him. He's 86 years old. He's her primary caretaker.
He has 2 children. He does work when he can at a restaurant. He's on call as a chef. I'm asking that you go along with the plea that we negotiated. We're only entering a plea under offered because to avoid trial, there's no outcome. He wasn't found in the house, he was outside. There was also another person who was found on the property. And he was breeding dogs at the time, and he was there to check on the dogs that he was breeding. And I watched the body cam, and that is true. There was dogs and puppies throughout the place. Didn't own the place. He doesn't know who owned the place. He was just told, hey, they have a girl or boy dog, we have another dog, come breed dogs, and then that's all he was there for.
Okay. All right. Mr. Edwards, anything you want to add?
Outside of what I just said, no, sir.
Okay. All right. Well, I find there's a factual basis for your plea and that your plea is knowing and voluntary. I see that in the 17 SC case, another drug case of yours, you've already been revoked for this conduct. Judge Eaton in October of 23 revoked you for 6 months. So we don't need to do anything with that case. This arrest and this case has already created consequences for you in your older drug case. Let me hear if we can reconnect with Ms. Jackson. Ms. Jackson, are you there?
Yes, Your Honor.
Hey, do you have criminal history information for Mr. Edwards?
Yes, sir. There are 18 cycles. The last arrest was June the 28th, 2017, with the City of Atlanta Police Department for trafficking cocaine and possession of marijuana with the intent to distribute and possession of Schedule I controlled substance. It does appear to be currently on probation for possession of cocaine with the intent to distribute. That case number is 17 SC 153046. That disposition date was February the 20th, 2018, and the term is for 28 years. He does have prior felony convictions. One in 2009 for possession of Schedule I controlled substance. One in 2006 out of Greene County, Georgia, for possession of controlled substance. And he does have a misdemeanor sentence and a conviction. He received a nolo contendere sentence in 2017 for possession of marijuana less than an ounce. And there was one in 2009, a conviction for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. All right, Mr. Edwards, I'm sentencing you pursuant to the Probation Options Management Act. You're already on probation for almost forever in that other case, but you'll be on probation for a while on this case as well. If you have technical violations, you and probation will sort those out. But if you get arrested for anything, that comes back to me, and we'll figure out what to do on the revocation side. I'm a little confused about the aunt thing. There's an aunt who's the matriarch. There's an aunt you're taking care of. Is that the same person?
The matriarch is the same one.
And that's the one you're taking care of?
That's the one I'm taking care of.
And then there's another
I
aunt.
got another one. She's my mother's, both of these are my mother's sister.
Okay.
My mother's passed, so, I gravitated towards them. And,
Okay.
The oldest one, she's the one got dementia, and my other aunt who stays on the other side of town, she has to come help me when I have to go to work or come to work.
Got it. Okay. And you've got a daughter in college.
Yes, sir.
Your other kid is how
My
old?
son he'll be 20 on the 25th of this month.
Okay. And is he local?
He stays in Macon.
Okay. Does he ever come take care of the aunt? What does he do in Macon?
He was working at a masonry company where he was stacking bricks on a pallet. About a week ago, he lost his job.
Oh.
And then yesterday, he just called and said he just made it.
Well, there you go. Another generation. Okay. Hopefully he finds another job.
He said he's supposed to be working at the Amazon warehouse.
Okay. All right. Well, congrats. Is that your first grandkid?
Yes, sir.
All right. So, Mr. Edwards, you need to be more thoughtful about the yards in which you breed dogs and the spaces. My guess is it wasn't a surprise to you what was going on in that house, whether it was your business or not. So you just need to be careful to stay away from things like that, because next time it won't be probation. What I'm going to do on the only count, which has been reduced to possession with intent to distribute, is sentence you to 10 years to serve 5 months. You'll get credit for the time you've already served in this case. The balance will be on probation. I'm going to repeat a condition that you have in your other case, and that's get your GED. I'm going to require you to be enrolled in a course within 3 months. Judge LaGrua's sentence required you to get your GED within 18 months. Haven't done that. Also required you to pay a chunk of the fine within a certain amount of time. You haven't done that. I appreciate you've got other things going on, but you're still able to try to raise dogs and do this and that. So you need to dial into these requirements. I expect probation to tell me if we are 4 months into your probation and you haven't enrolled in a GED course. You can take the course at your pace, given all the other things you have going on, but you've got to get it started and make sure you're making progress there. You'll also need to stay away from that address on Dill Avenue where the dogs and the drugs were. Ms. Rios, and you live in Fulton County? Okay. Ms. Rios, anything else on behalf of Mr. Edwards? Ms. Davis?
No, Your Honor.
All right. Ms. Simpson is with probation. She's seated right there. She's going to give you, I guess, is it reporting instructions? He already has a probation officer. Got it. Well, you will be given that to Ms. Simpson, and you may need to report again with the new address. Let me see what we've got for you to see if that's what is in the system. I've got you on Hendricks Avenue. Okay.
So that is the same.
All right. Well, good. Anyway, talk with Ms. Simpson. She's going to let you know what you need to do to plug in with probation on this case. All right. All right, thank you. All right, let's figure out what we're going to do with the remaining situations. I saw that. Thank you.
He's coming back. He's good.
All right, if we go through the calendar, Rogers and Mender, we will set down for a week plus to what we talked about.
And Your Honor, I'm sorry, this is Christy Godden. I apologize that I'm just now approaching.
You're approaching what?
Well, I just turned 60 and I have prepared for 3 trials in the last month and a half. And I just had an embarrassing issue today. And I'm asking that the court set this case down for a new court date.
Okay. We'll talk about that in a sec. We haven't gotten to your cases.
Okay.
Sorry.
I'm so sorry, Judge.
Okay. Sit tight. Ms. Taylor, good morning.
Good morning, I made it
You did.
before the morning was over.
So Mr. Bateman is here. What are we doing with his cases?
Mr. Baker, we do have a negotiated plea, however, there is one count that I need to talk further with the state about, or if I could have a moment to talk with them about it. I believe we have Mr. Baker resolved this case.
Okay, and how about Ms. Hightower?
Ms. Hightower just wrote on the trial calendar and, I've talked with the state and certainly don't have any kind of negotiating here on Ms. Hightower, so I guess we have to.
Stay on the trial calendar.
Yeah.
Got it. All right. And that gets us to you, Ms. Gladden. You represent Mr. Perry, the co-defendant.
Yeah.
You ready for trial? Trial's not today. Trial's not tomorrow. It's not till the 23rd, but are you good to go on that?
Yes, sure. Yes, Judge. I was actually prepared for trial today. So yes, we're prepared.
Okay. All right. So Ms. Taylor and Ms. Gladden, you'll be getting an email from me, along with the other lawyers to include the prosecutor and other defense attorneys, that lists the order in which we're going to try cases the week of the 23rd, and Hightower and Perry will be on that list. So watch for an email. Ms. Davis, anything you want to add about the Hightower Perry situation?
No, you're that's fine.
Okay, all right. Then Ms. Gladden, you are good to go. But before you go, Mr. Perry, any questions about your situation?
Yes, I was brought on the second, to Miss Madden, that my original jail by the land marshal. And, she said she couldn't remove it because my case was in your courtroom and she was gonna email me because I've been on way over the center and I've been compliant. She checked with the compliant people at the scene. How I've been compliant, head boss, haven't got any trouble. And she said she was gonna email you, but she was the original judge of the law to remove it because I've been compliant with.
Right. No, I'm aware. And your trial is a week and a few days from now. So it seems to me, that we ought not to remove it just before trial. If we don't reach your case for trial, then we ought to have that conversation. But I'm comfortable keeping it on for another week so that we know how to find you in case you don't show up for trial. Okay? Yes, Ms. Hightower.
I'll talk to Ms. Hightower.
Okay, she just raised her hand. I'm not trying to go around you, Ms. Taylor. I just, so why don't you and your lawyer talk, okay? All right, so let me keep pushing through the calendar here and then we'll circle back to Mr. Bateman. All right, Mr. Slayton, what do we need to do with Mr. Thomas today?
Well, I would like to have a Jackson County hearing at some point for trial regarding the state in custody. And then another issue I have is the grievances he was filing in Fulton County Jail are going to be crucial for us. And that would be the process. I tried to serve subpoena at the jail. I told him it would be a records process, which I did. And normally I would just take what I received and say, okay, thank you. But I have some physical grievances that were not included in what was provided to me. So there's some kind of variance. And I'm not really sure how to go about making sure I have the entirety of the grievance list.
Okay, have you filed the Jackson Dental motion and I just didn't see it in the docket, or you will be filing one? Okay, your understanding from the evidence you've received is that there was some sheriff's office, Mr. Thomas interaction after the incident? Okay, and your understanding is the state wants to use that statement?
I'm not sure if they can use the statement or not. I mean, if they would consent to not using the statement, I would not allow that.
Okay. All right, do you know at this point, Ms. Davis, if it's something you're gonna use?
No, Your Honor, I don't know at this point. Also, I don't have whatever was received from Fulton County Sheriff's Office, so I would ask for that information to be shared with the state.
I emailed it to you afterwards, so it is in the stairs, as of like 30 minutes ago. And then additionally, the video of this incident is just, it's one part of a bigger picture. And I think that preceding this the day before, there was kind of a shakedown and some violent interaction the day before. Now, normally what I would like to do is say I'd like the video footage for these certain hours, but I'm not sure exactly what time, so I'd like to have this, I believe it's 7 North from 7 a.m. to midnight. I know that's a ton of footage, but I think that would be
very important to the defense of this case.
So I asked the sheriff's team about that, and they're not comfortable providing extended blocks of surveillance footage because it shows when patrol happens and this and that. So we can get someone here from the sheriff's office who can explain the discrepancy with the grievances, but we can have a discussion about that. I need to strike the right balance between you looking for what you're looking for and the security concerns as to why you wouldn't say, here's 4 hours so you can see this is when the changing of the guard occurs, and ooh, look, there's a gap in the way they are patrolling. So I respect the sheriff's team's reluctance to share that. It's different from saying, I want all the surveillance from the gas station for 24 hours. You get that. This is different. So I don't know if you and Mr. Thomas are going to be in a position to say, it actually was 1 hour before or what. And it could be that the way we do it is you sit and watch it, but you don't get it. But as you're watching it, I need to say that more clearly, that we set it up so that you can view it once, and then you can make a note of, I want footage for this 22 minutes, this 17 seconds. But you don't get to keep the full 3 hours or 8 hours or whatever it is. Does that make sense?
Absolutely, that makes perfect sense.
Okay.
I appreciate you explaining that. And then also I'd like if they do plan to, as I'm told, to call the victim to testify in this case, I'd like to have any gang affiliation or any deals or incentives made to him under Brady and Powell's or Whitley.
Okay, I don't know about the first one. I mean, I guess if the state knows about it, they'd tell you about that, but you certainly are entitled to any incentives that were offered. But you mentioned that before, so we'll work through that. It sounds like we need to set this down for a hearing, one for Jackson Deno, and two, get someone from the sheriff's office here. We'll do it all at the same hearing, so that we can have a discussion about getting you and the state the paperwork and, well, I have your order here, the proposed order. You wanted incident reports related to Mr. Britton. You got that, check, okay. You wanted all the grievances on file made by Mr. Thomas. That's the discrepancy you've mentioned. You want an incident report pertaining to Mr. Blake's death. You've received that, okay. I was told that's the one you're not going to get. And then you wanted a window of surveillance footage.
Yes, and the reason for that, Your Honor, is my client was, in fear for his life about what was going on, and he's indicated to me that he took his sleeping mat out of his cell and slept in front of the stairwell, basically because he's aware that's where the camera is.
Got it. And so you want to be able to verify that?
Correct.
Okay, that's fine. We'll see what they still have. And like I said, if you're not quite sure the window you need, then we might have for viewing only, not recording on recording. You can watch as much as you want, and then you're identifying, here I'd like to keep these snippets.
Right, and I understand that logic behind everything makes perfect sense to me. And also, I'd like just a witness list as soon as possible for this. I guess that's per OCGA 1768, it's 10 days before trial, which I guess would be, I think, tomorrow, if I'm not incorrect.
Right, although I don't know that we'll get the Jackson Deno done in time, so I don't know that we'll get to trial, but we'll see.
That's fine, Your Honor. And part of that is one, for me to prepare, and two, if I need to, I don't wanna, have to subpoena a bunch of corrections officers if they're already planning on being.
Right. No. Asking for a witness list is a reasonable request, and Ms. Davis is juggling a bunch of cases. She needs to see what the short list is, and I'm sure she'll get those things out.
Your Honor, I appreciate the clarification. I'll file my Jackson Deno hearing and go from there.
Okay. Do I need to talk to Mr. Thomas at all, or you'll let him know, look, our next stop is the Jackson Deno hearing, and he'll be here for that?
I'll go back and speak with him again, but I've made him aware of what's going on. But
Okay. All right. Thank you, Ms. Davis. Anything on behalf of the state in connection with Mr. Thomas? Okay. Great.
Thank you, Your Honor.
You're welcome. Ms. Kemp wants to go to trial now. Mr. Bass,
Yes, sir.
how are you?
I am greatly appreciative of holding tomorrow court. I will be Clayton with.
Ms. Taylor, yeah, why does Clayton get all the love and we're always second?
And then they have 60 people on the calendar, and then you have a thing for them going.
Good old Judge Mac. Okay.
That when you get ahead of everybody else, it's put at 8 o'clock.
Yep. Okay. That's one way to do it.
I would amend my announcement. I've been announcing ready. I would amend it to really.
Well, and I'm aware of that. And so you're actually on two different calendars. You're on this calendar to try with me the week of the 23rd, or with Judge Emerson, who does our consolidated calendar. And I only had two cases on there. One of them pled today. So if my position is reached by Judge Emerson, it's Mr. Dennis.
So if I'm not mistaken, there was a calendar starting this coming Monday.
Correct.
Is that the one you're referring to?
Yes, and you're on the email. I just sent an updated email.
Possibly second or first, this coming Monday, if you get a plea.
No, let me be clear. I don't want to, well, I just want to manage expectations. So, we've got Stevens and Park ahead of Dennis
This coming Monday.
for this coming Monday.
So I'm within 3 this month.
Correct. Yeah, because this just in, there was a case that I had always said in these emails, everyone's asked for a continuance, but that judge hasn't done anything, and that judge just granted the continuance. So Stevens, then Park, so it's a Leffridge case, and then a Judge Ingram case, and then Mr. Dennis.
Now, what is your preference with regard to his clothing? Bring it in Friday just in case I'm reaching home.
It's been in the email. You should be bringing the clothing here the Friday before, so that would be tomorrow. And then we'll make sure it gets down to 1D. All right? And it's also on my 1 week trial calendar, which is the following week. You and Mr. Abate can only be in one place at one time. So if what happens next week is that Judge Emerson tries Stevens or Park, we would be up, we meaning the Dennis case would be up first for that second week of Emerson, which is the week I'm also going to trial here. And so I need to figure out, am I going to release Mr. Abate from what I might be trying here so that he can do Dennis in front of Emerson, and then I find something else to try. So there are a few balls in the air. Your focus should be, hey, I'm number 3 for next Monday in front of Emerson, and I'll bet you Stevens doesn't go forward. So it would be 1 ahead of you, and that's Park. And I think that's Ms. Lake is the defense attorney, and Ms. Robinson is the prosecutor. So you can be bugging them to say, what's going to happen with that case? Okay?
Thank you.
Mr. Abate, anything you want to add? Okay, thanks.
Thank you. And that is my only matter on the calendar.
You're good to go.
We read on this debate.
I'm not, unfortunately. I gotta go. So before you go, I want to figure out a time when we can do this. Are you available tomorrow?
Yes.
What time works for you tomorrow?
I would say 10, Jerry, because I actually have 11 o'clock probation lounge. And I think it's gonna be a non-conference room. I have to find out. It's at 11.
Okay.
I would say 10 o'clock.
All right. But it's in this building?
Yes.
Okay, so, got it, okay, NC1. So we could do 10:30? Yes, because I have a summary judgment hearing at 9:30. And so if we did 10:30, Mr. Bateman, are you able to be here at 10:30 tomorrow? I know you want to, but I gotta go. I've been here all morning, but Miss Taylor was tied up in Clayton County. And so schedules haven't gone well.
Yes, I don't have a choice.
Okay, well, I mean, if you were to say tomorrow, I have to get this young lady to the airport, then we would do it next week. But like you, I'm ready to get it taken care of. And so if we do 10:30, don't come early. I don't want you sitting around anymore. You gotta promise you'll wear the same red jacket though. But
The last time he was here, we talked about his appearance, and so I said, oh, you look like you're going to the prom today.
can you be here by 10:30 tomorrow? Okay, Ms. Davis, can we do 10:30 tomorrow for Bateman? All right, done. I don't think we've got anything else. Who else is still here who needs to talk? Nope. You guys, you're free to talk with Ms. Taylor, but what they've both announced is that you guys are ready for trial. So we'll be seeing you guys not next Monday, but the Monday after.
I can't help it. One thing I would want, if that shit was possible, I can have a gun in my home, because I live in my home.
So not something I'm going to change before trial. Trial is a week away. So for one more week, no gun in your home, okay? All right. Ms. Wood, anything else?
No, Judge.
Ms. Rios? Ms. Davis? Thank you, guys. Thanks, Ms. Simpson. Deputy Gordon. I'm sorry I didn't get to see Mr. Thomas. Who kept banging on the door? Was it Thomas or Dennis? They are eager folks.
I don't know. Case. Oh, yeah, you have to go. Single, but you're still on.
Mm-hmm. Thank you for adding Bateman. Yeah.
Do you want, Miss Jackson on?
Yes, please, if we can do that. Thank you, Ms. Jackson and Ms. Rivers.